Well, hello and welcome to another Sunday Coffee with Dr. Childress here. So, in this particular video segment, I'm going to be speaking directly to the court regarding the nature of the pathology and my recommendations from a healthcare perspective about what to do um, to resolve the family conflict in the child's attachment pathology. So, to begin with, let me introduce myself to the court. I'm a court-involved clinical psychologist. I am not a forensic psychologist. I do not conduct forensic custody evaluations, and I am not concerned with the child's custody. I am concerned with the child's pathology, the attachment pathology, rejection of a parent, and the family conflict, and the mental health resolution of the child's pathology and the family conflict. So my focus is on diagnosis and treatment, and that custody is the court's decision. Now, let me say something from clinical psychology about that, which is in the absence of child abuse, parents have the right to parent according to their cultural values, their personal values, and their religious values. And in the absence of child abuse, each parent should have as much time and involvement with the child as possible. And in the absence of child abuse, to restrict either parent's time and involvement with the child would damage that child's attachment bond to that parent, thereby harming the child and harming that parent. And so the question for clinical psychology is there child abuse? And that's the relevant question for the court's consideration as well. And so these two concerns, the concerns of the court and the concerns of clinical psychology, align with around the issue of whether or not there's child abuse. And if we have a child rejecting a parent, there is very likely to be child abuse by one parent or the other. And which parent becomes the relevant diagnostic question and relevant question for the court's consideration. Which parent is abusing the child, creating the child's attachment pathology towards the other parent? Now, my background, the reason I'm a court-involved clinical psychologist and consultant in the family courts, is that I bring 6 domains of specialized expertise in clinical psychology relevant to the pathology in the family courts. And these are supported by my vita. So I have background in attachment and attachment pathology. I have early childhood mental health specialization. I have background in the diagnostic assessment of delusional thought disorders, 12 years at UCLA being trained in the diagnostic assessment of delusional thought disorders. I have background in child abuse and complex trauma. I was a clinical director for a 3-university assessment and treatment center for children in foster care. Child Protective Services was our primary referral source. I have background in factitious disorders imposed on the child. I was trained at Children's Hospital, Los Angeles, and served on medical staff as a pediatric psychologist at Children's Hospital of Orange County, which is the locations where the factitious disorders imposed on a child typically show up. I have background in and expertise in family systems and family systems therapy. That's specialized training from Pepperdine University, plus that's the paradigm, or that's the approach from which I work. I know strategic, I know structural, I know Bowenian, a variety of the various models in family systems therapy. And I'm involved with court-involved custody conflict. I've been in the family courts for the past 15 years. I offer additional resources to parents and attorneys and mental health professionals and to the court regarding the pathology in the family courts. And particularly, I'd recommend my online YouTube series, the seminars on diagnosis. Currently, I have 6 segments of the diagnosis series up to my consulting page of my YouTube channel is the most convenient place to reach the most relevant YouTube seminars I have. I also have a YouTube channel where they with a lot more content, but my consulting website on the YouTube page has the primary and most valuable of the YouTube seminars. Also, I would recommend that court-involved professionals, legal professionals, GALs, parenting coordinators, attorneys, parents, everybody can follow me on Blue Sky social media, and I post regularly about the pathology in the family there. In particular, though, I would recommend my diagnostic series. As I said, there's currently 6 up there, and I'll be proceeding with more as time goes by and I have the available time. The first one is about the DSM-5 diagnosis of family court pathology. Second seminar is on forensic psychology and a quasi-judicial role for doctors. That was a mistake. It's a bad thing to do. Then I have a seminar on how to assess for parenting. And these are at the professional level for the mental health professionals. So, Your Honor, if you watch these, this will be giving you background in what the doctors should be doing and how we go about diagnosing pathology. Then, and so that would be the parenting assessment on that. And then I get specifically into how we diagnose the various aspects of the pathology in the family, beginning with diagnosing a persecutory delusion. It's a mental status exam of thought and perception, and I describe that. Then the next seminar is diagnosing a factitious disorder imposed on the child, in this case, a factitious attachment pathology, a problem in love and bonding, sometimes a factitious anxiety disorder, a phobic anxiety, but it's a factitious disorder imposed on another. And then the one I highly recommend that everybody watch is diagnosing child abuse in the family courts. Let me say something about that. All mental health professionals have duty to protect obligations. And for 3 types of dangerous pathology: suicide, homicide, and abuse, child abuse, spousal abuse, and elder abuse. That's a category of pathology called dangerousness. And whenever we encounter a dangerous pathology, we have 3 obligations: to personally conduct a risk assessment for the danger involved or ensure that one gets conducted, to take some sort of affirmative protective action, such as increasing frequency of sessions or referral to an ER for suicidal patients, something like that. And then third, to document in the patient's medical record both the outcome of the risk assessment, if we conducted one, and what affirmative protective action we took. That's with all dangerous pathology: suicide, homicide, and abuse. When we have a child who seeks to reject a parent, who seeks to flee from a parent, a clinical concern immediately becomes possible child abuse by that parent or psychological child abuse by the other parent. So immediately, when a child's seeking to flee a parent, that's a child abuse concern is on the table. So duty to protect obligations are active. In addition, a second abuse concern relative to family court pathology is the possible spousal psychological abuse of the targeted parent by the allied parent using the child as a weapon. So with this pathology, we have 2 possible dangerous pathologies: possible child abuse and possible spousal abuse. Duty to protect obligations are active for all mental health professionals, and a proper risk assessment should be conducted. However, it's not being conducted by the mental health professionals who are working in the family courts, which is a significant problem. So seminar 6 there discusses the child abuse and the assessment of child abuse in the family courts. The problem that the courts face is a failed mental health system. And specifically, the problem is that the court is not receiving the necessary information from the doctors regarding a diagnosis of the child's pathology and the family conflict that the court needs for its decision-making surrounding the child. And we'll talk about why that is in a bit. But when we have a situation where a child is rejecting a parent, And it is this attachment pathology, a problem in love and bonding, that's causing the need for the court's ongoing involvement with the family through a custody conflict. The issue is treatment, not custody. The issue is the child's pathology that is driving the issue into the court system for around custody, but it's not a custody issue. It's a treatment issue. The court is fully capable of deciding on custody once it receives an accurate diagnosis from healthcare regarding which parent is causing the child's pathology and family conflict. What happened was the forensic psychologists back in the 80s, they tried this experiment, this quasi-judicial role for doctors because they believe the court needs assistance in its custody decision. I disagree. I think the court is entirely capable of deciding on custody schedules and what the custody should be. The complicating factor is the child's pathology. The child rejecting a parent, that's an attachment pathology, and the conflict about which parent is causing that. Each parent's alleging the other parent is causing the child's pathology. That's a healthcare issue. We need to get it out to the doctors for a diagnosis and treatment plan to fix it. What happened was the forensic psychologists left the field of healthcare, tried to be mini judges and assumed the roles of the judges in deciding on custody. And that means the judges now have to diagnose the pathology because the doctors aren't. They're making custody decisions, and everybody's out of their role. We need to get back into our roles and then work together. And so judges, the court decides on custody, doctors diagnose and treat pathology, and then we can work together for the resolution of the family issues. So there is a problematic parent in this family because all normal range parents handle post-divorce custody without needing the court's involvement. So the mere fact that we have an ongoing custody conflict means that we have a non-normal parent who is creating the need for the court's continuing involvement. So, the court can decide on custody at the initial divorce and separation. But if that issue comes back to the court after its decision making, then we have a non-normal parent in the family. And the parental personality pathology of concern regarding high conflict issues and things are the narcissistic, borderline, and dark spectrum personalities, particularly the dark spectrum. And these are subclinical variants of the narcissistic borderline pathology. There's 3 dark personalities. The first, and these are identified in the research literature, they're a constellation of particularly malevolent personality traits. The dark triad is narcissistic, psychopathic, and highly manipulative, Machiavellian levels of manipulation. The other variant is the vulnerable dark triad. That's vulnerable narcissism, highly manipulative, type 2 or factor 2 psychopathy, and borderline personality characteristics. Then if we add sadism to the dark triad, that's the dark tetrad, and that's a particularly malevolent person. That's narcissistic, psychopathic, manipulative, and sadistic. And that's the type of personality we have in the family courts, or these dark personalities. Now, basically, we have 2 variants, gender-related variants. We have typically a narcissistic dad variant that has higher spousal abuse feels to it, and that's your dark triad and your dark tetrad personalities. And then we have the borderline mom variant, which is the vulnerable dark triad, has higher false allegations and higher anxiety associated with it. Now, the gender is not hard and fast, but it typically falls into those 2 types of patterns. And once you recognize the symptoms of the patterns, they become relatively easy to identify. From the research literature, from Gianmarco and Vernon, they describe the dark triad. So first cited by Paul Huss and Williams The dark triad refers to a set of three distinct but related antisocial personality traits: Machiavellianism, narcissism, and psychopathy. And it's that manipulation that is involved with the courts. So each of the dark triad traits is associated with feelings of superiority and privilege. You may find these parents often disregarding court orders. They're just entitled to, disregard limits placed on their behavior. This, coupled with a lack of remorse and empathy. The absence of empathy is a capacity for cruelty. So this, coupled with the lack of remorse and empathy, often leads these individuals high in these socially malevolent traits to exploit others for their own personal gain. And that's what's going on. We have a dark triad parent, or vulnerable dark triad, dark tetrad, who is producing symptoms in the child and then exploiting the child to manipulate the court and for spousal abuse and for various other personal reasons. The dark triad is associated with judicial manipulation. Here's from Clemente, Padilla, Rosero, and Espinosa. This research examines the relationship between dark triad and the use that some parents make of their children in order to attack the other parent after a couple breakup. Results show significant correlations for judicial manipulation and dark triad traits, and confirm the psychometric properties of reliability and validity of a proposed scale. We found that dark triad traits are adequate indicators of judicial manipulation. And that's what we're concerned about relative to one of the parents. And then from Monfa Arigario, unfortunately, I apologize for the name, and Shermer, regarding the vulnerable dark triad. Here, VDT. Here we have factor 2 psychopathy, vulnerable narcissism, and borderline personality traits. And it was proposed over 10 years ago as a counterpart to the dark triad, narcissism, psychopathy, and Machiavellianism. And it combines socially undesirable behaviors and emotionally vulnerable traits. The interplay of vulnerable behavior can lead to a complex pattern of emotional instability, a fragile sense of self, relationship difficulties, and manipulative tendencies. And it's the manipulation that is of direct concern. So the question for the family courts, when we have a child rejecting a parent, because the attachment system is a bonding system. It motivates the child to bond to the parent. And all motivation systems have a direction. Eating, pain, pleasure, sex, they all motivate towards a direction. And here we have a child seeking to flee a parent. Well, when a child is rejecting a parent, there is a non-normal parent, a narcissistic, borderline, dark personality parent of concern somewhere in the family. When you have that symptom feature of the child, either a narcissistic, borderline, dark spectrum targeted parent who is abusing the child in some way, thereby creating the child's rejection of that parent, or a narcissistic, borderline, dark spectrum allied parent who is creating a false or factitious pathology in the child for secondary gain to the parent of manipulating the court's decisions on child custody. If we reward the parent for producing pathology in the child by giving that parent custody of the child, you will have that parent producing, that dark personality parent producing pathology in the child to manipulate the court's decisions. The secondary gain or reward to the narcissistic, borderline, dark personality parent for producing false pathology or factitious attachment pathology in the child is first court manipulation, to manipulate the court's decisions regarding child custody by producing pathology in the child and getting everybody afraid and getting, restraining orders or efforts at supervised visitation and everything because they're making false allegations of abuse, or the spousal abuse of the targeted parent, using the child and the child's induced pathology as a spousal abuse weapon. And the third potential secondary gain or reward to the pathological parent is using the child as a regulatory object to meet the parent's own emotional and psychological needs. And again, if we reward producing pathology in the child, then we will have these dark personality parents producing false pathology in the child for their secondary gain, for the reward. So the legal system response that I recommend is a psychological consultation model. So first off, for its decision making surrounding the child, the court needs an accurate diagnosis from healthcare, from the doctors, regarding which parent is creating the child's attachment pathology. And that's the obligation of healthcare, and we are failing the courts in providing that information that they need. So now, in addition, any diagnosis that's returned into the legal system will be a disputed diagnosis. It will be challenged by one side or the other because that's the legal system. It's an adversarial system. The appellate system in healthcare for a disputed diagnosis is second opinion, which is exactly the same in the legal system. If you appeal a court's decision, it goes to other judges, second opinion judges, the appellate judges. Same thing in healthcare. We use a second opinion to appeal diagnoses. The two systems, the mental health system and the legal system, are based on the same structure. And the legal system likes to get its second opinion in a very linear fashion because it likes everything documented. Over in the healthcare system, we need our diagnosis early and accurate. So we pull our appellate system right up front. And so you know this from healthcare. You go into the doctor, you say, "Doctor, this hurts." And you say, "Let's get a second opinion orthopedic consult." We consult early and often because we need an accurate diagnosis to guide our treatment plan. And we can't delay on the treatment because things can get worse and worse. So our appellate system starts real early. And that's the what I would recommend that the court make use of. So we have two litigants. There are two allegations of abuse within the legal system. Each parent is alleging that the other parent is abusing the child in some way. So we have litigant A, who the allied parent, who is alleging that the child is being abused in some way by the other parent, by litigant B, and that this abusive parenting is creating the child's attachment pathology towards that parent. By contrast, we have the second litigant, litigant B, the targeted parent, who's alleging that the child is being psychologically abused by the allied parent, litigant A, who is creating a persecutory delusion and false factitious attachment pathology in the child for secondary gain. So we have two litigants, each alleging child abuse. What I recommend is a consultation model in healthcare for the doctors to return an accurate diagnosis that the court can rely on. So in this model, the court would designate a primary psychologist to conduct the diagnostic assessment and then allow each litigant parent to appoint a second opinion consultant of their choice to participate in that assessment through telehealth. That will create a 3-doctor panel with analogous over to a 3-judge appellate panel. So you will get the primary decision out of the primary psychologist assigned to conduct the assessment, then you will get 2 second opinions on that diagnosis. And then the court can make its decisions based on that diagnosis, and then we can develop a treatment plan based on that diagnosis to fix the problem. Now, another way of looking at the same consultation model, flipping it on its side and extending it out into treatment, is that these consultants to the initial diagnostic assessment can then also serve as consultation resources for the mental health treatment providers as it moves into treatment to ensure successful treatment. And that's what we do in healthcare. We consult all the time. So I recommend that we get consultants on the diagnosis and consultants on the treatment plan because this is a very dangerous pathology. We have possible child abuse in this situation. And I've worked child abuse. I've personally treated all 4 forms of child abuse as clinical director. CPS was referring their kids into us for child abuse. When child abuse is a considered diagnosis, our diagnosis has to be accurate 100% of the time, because the consequences for misdiagnosing child abuse are too devastating for the child. So from the doctor perspective, from the healthcare perspective, we have to do whatever we need to do to make sure that that diagnosis is accurate for an effective treatment plan and for child protective reasons and for the court's decision making surrounding the child. The first step to do that is to pull in second opinion consultation on that to improve the quality of the diagnosis and stop the fighting around the child. Let's get our second opinions right up front on that diagnosis. And then there's other things we can do, such as response to intervention, and we can apply behavioral analysis. There's other things we can do to ensure that we have an accurate diagnosis 100% of the time. And that's what we need to be doing in healthcare. We need to discontinue the forensic custody evaluations and go back to a clinical diagnostic model of treatment for the child's pathology. So this is the obligation of the doctors, of the mental health system. It is the obligation of the mental health system, the doctors, to provide the court with an accurate diagnosis for the child's attachment pathology and the family conflict for the court's decision-making, and to develop an effective treatment plan to fix the diagnosed problem. In all cases of court-involved custody conflict involving severe attachment pathology displayed by the child rejecting a parent, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnoses for each parent. And here is the differential diagnoses we're concerned about in healthcare. Either the targeted parent is abusing the child in some way, creating the child's attachment pathology towards that parent, in which case we need to identify, diagnose what the child abuse is: physical, sexual, neglect, psychological, put it on a treatment plan, fix it, and restore the child's attachment bond to the now fixed abusive parent. Or, which is the clinical concern of relative to the family courts of high clinical concern, it is the allied parent who is psychologically abusing the child by creating a delusional disorder, persecutory type, shared induced delusional disorder, a factitious disorder imposed on the child, factitious attachment pathology for secondary gain. Either one or both of those would result in a child psychological abuse diagnosis, and then the additional consideration of spouse or partner abuse, psychological, of the targeted parent by the allied parent using the child as a weapon. So that right there is the differential diagnoses of concern, and we need a proper assessment to see which one of those causal factors are creating the child's pathology. And here is the 4 questions that the court should always be getting back from the mental health provider. These are the 4 questions the court needs answered. These are the 4 questions that I, as a second opinion doctor, need answered for the treatment plan. The first, is the targeted parent abusive? Is the targeted parent abusing the child in some way, creating the child's attachment pathology towards that parent? If yes, specify the type of abuse. If second question, yes, no. Is the allied parent abusive? Is the allied parent psychologically abusing the child by creating a shared persecutory delusion in the child? Yes or no. Third question, is the allied parent abusive again? Is the allied parent psychologically abusing the child by creating a false, factitious attachment pathology in the child for secondary gain to the parent? Yes or no? Fourth question, is the allied parent using the child as a weapon of psychological spousal abuse of the targeted parent? Now, let me say something about the full diagnosis. The reason we want a full diagnosis, both of the delusional disorder and the factitious disorder, A persecutory delusion is a thought disorder, belief that the child is being victimized when they're not. That's a thought disorder. That's a problem in thinking, and it comes from unresolved trauma that's kind of distorted their thinking and perception about situations, to see dangers where none exist. So that's a thinking problem. And the treatment for that would be to correct the child's perceptions about parenting and what's normal and what's not. The factitious disorder is a false attachment pathology. That's a love and bonding system. That's an emotional, relational disorder. And so the treatment plan for that would be to fix the bonding, the emotional bonding. So the diagnoses would guide different aspects of the treatment plan. And then we have a child abuse, child psychological abuse that would require protective separation. And then we'd start to resolve the child abuse and things off of that. And then we have an additional spousal abuse diagnosis that we have to consider under our duty to protect obligations. So that's why we want the full and complete diagnosis rather than just pieces of things. The mental health reports. So let me speak a little bit about what you should be receiving in the courts from the mental health professionals. You should always receive a clear diagnosis from the doctors. There should be no question about what the doctor's diagnosis is. Unfortunately, you have questions after you get a forensic custody evaluation. They do not diagnose pathology. The forensic psychologists in the family courts, which is highly problematic. It forces the courts to diagnose because the doctors aren't. They're failing in their obligations. So within the legal system has a procedure for collecting evidence. They conduct a trial to collect the evidence. Then the judge renders your verdict, and in that, when you render your verdict, you describe the evidence that was collected at the trial. You identify the relevant statutes to that evidence, and then you apply the relevant statutes to the evidence to reach your decision, and you kind of show your thinking process about how that applies to your decision or your verdict. Now, that is exactly the same thing that doctors do. And we collect our evidence in our clinical interviews, and we collect symptom evidence. Then in our reports, and what you should be expecting from our reports to the court is that we describe the symptoms, then we identify the relevant diagnostic criteria that was applied to those symptoms, and then we apply the diagnostic criteria, the symptom evidence, to reach our decision, our diagnosis. So those are exactly the same processes, and you should be getting a report from the doctors that is commensurate to what you write when you render a decision. You're not getting that. You're getting these awful forensic custody evaluations that just tape record or audio record their interviews and present that for 40, 50 pages, and then they don't diagnose the pathology. They are just awful mental health reports. They're an experiment in a quasi-judicial role for doctors. Everywhere else in psychology, we get a good diagnosis, a good report. We describe the symptom evidence, we describe the diagnostic criteria, we apply the diagnostic criteria to reach our diagnosis. And you, as the court, should be able to follow along in our thinking process and see that. Now, if it's appealed and you dispute the diagnosis, you get a second opinion on it. The second opinion doctor can then look at the symptoms, look at the diagnostic criteria, see if everything lines up, because the second opinion is not your presiding doctor. It's not your trial court judge. That's a second opinion doctor. That's an appellate doctor. And so I'm not going to retry the case as a second opinion, looking at document reviews. I'm going to look at what were the symptoms, what were the diagnostic criteria, were they properly applied, were there additional criteria that weren't applied or something? Does the diagnostic criteria describe all the symptoms? I'm going to be looking at procedures on this, and does it make sense? And you, Your Honor, should be able to do the same thing. Okay, you should be able to look at a mental health report and be very clear on what the symptoms were, what the diagnostic criteria are, um, and why that doctor reached that decision. And that's when you get a second opinion consultants or third opinion off of this. When you get three doctor reports about the same issue, the doctor reports should pretty much agree with what the symptoms are, what the diagnostic criteria are. There might be minor little disagreements. Does this symptom meet this criteria kind of thing? But the court can make decisions around that. Once you get your quality reports back from the mental health doctors, the court can decide as to credibility and what the situation looks like relative to the court's decision making. The court and doctors do different things, and we should remain in our roles of doing different things, and then we can work together. So there should be no uncertainty about a judge's verdict, about what the evidence was, what the statutes were applied, and what the verdict is. There should equally be no uncertainty about a doctor's diagnosis, about what the symptoms were, what the diagnostic criteria were applied, and what the diagnosis is. Okay. Now, that's unfortunately not the case in forensic custody evaluators who don't diagnose. They are withholding diagnostic information from the court that the court needs for its decision making. I find that extremely problematic for doctors to withhold information from the court, to manipulate the court's decisions in favor of the pathological parent. Because if they tell you the diagnosis of child abuse by one parent or delusional thought disorder by one parent, that's going to prejudice the case against the pathological parent. But it's going to be probative to the targeted parent who wants the judge to realize the other parent's abusing the child and creating a false disorder in the child. However, the forensic psychologists are withholding that information from the court and from the litigants so that the targeted parent cannot make a full argument to the court because they don't have the diagnostic information that they would need to make that argument. Because the forensic psychologists don't diagnose pathology. They're doing something different. They're quasi-judicial role. And so I'm in the family courts assisting the mental health professionals to return to standard healthcare practices and provide the courts with an accurate diagnosis of the problem and both litigants so that we can fix the problem. The forensic custody evaluations, also called parenting plan assessments, voice of the child up in Canada. They're called various things, but the court understands what we're talking about. Those big 6 to 9 month, $20,000 to $40,000 assessments that come back and are marginally helpful, if at all. I don't think they're helpful at all. And they're highly problematic for a variety of reasons. Those type of evaluations and that role, this quasi-judicial role, are a failed experiment in this quasi-judicial role for doctors of assisting the court on its custody decisions. There is no quasi-judicial role for doctors. That is an experimental role. It completely failed. It was an inappropriate experiment on human subjects, the parents and children in the family courts without proper oversight. Courts decide on custody. Doctors diagnose and treat pathology. We need to get back to our roles. When the doctors fail to diagnose pathology, as the forensic custody evaluators have, that then puts the court in a position where the court needs to diagnose what the problem is. And that's not the background. You're not trained in mental health issues, and it's a very complicated and very sophisticated pathology. And so, but the court has to do that if you're not getting clear information about the diagnosis from the doctors. So the doctors need to go back and stop worrying about custody, go back and focus on diagnosis and treatment, provide the court with an accurate diagnosis of what's going on in the family, and then the court can apply its legal statutes and decide on whatever issues that are before the court. The New York Blue Ribbon Commission, New York appointed a Blue Ribbon Commission to look at forensic custody evaluations. And here's one of the findings, and I recommend everybody, all the legal professionals, become familiar with this New York Blue Ribbon Commission on Forensic Custody Evaluations. By an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence or child abuse. And there's a discussion, in addition to the Blue Ribbon Commission, there's a discussion up on YouTube from two of the commissioners that both happen to be attorneys, regarding their findings of the New York Blue Ribbon Commission report on forensic custody evaluations. And I recommend all attorneys and all judges watch the discussion from these two attorney commissioners regarding the problematic issues from forensic custody evaluations. Now, I am a second opinion review for these evaluations. They're brought to me, these defective reports, and I'll go through them line by line and take them apart and provide a second opinion report regarding forensic custody evaluations. I get to read them. I've read a number of them. I am the meaningful scrutiny that the Blue Ribbon Commission talks about being necessary. And from my role as a second opinion consultant on these forensic custody evaluations, I am in 100% agreement with the New York Blue Ribbon Commission. They need to be eliminated entirely from the family courts. They are a failed experiment on human subjects. There is no quasi-judicial role for doctors. Doctors need to go back to diagnosing and treating pathology. The courts can decide on custody just fine if we get them accurate diagnostic information. So I am in 100% agreement with the New York Blue Ribbon Commission regarding the elimination. They are dangerous, they are harmful to children, and they lead to potentially disastrous consequences for parents and children. Another quote from the New York Blue Ribbon Commission. So to describe my role as I close up my talk with the court, I have two clients when I'm brought into the matter as a second opinion consultant, by the parent and their attorney. My first client is the child, and that's true in all cases of family therapy or family situations. My client is always the child. But when the court's involved, I get a second client, and that's the court. My obligation to my child client is to ensure that the child receives an accurate diagnosis of the problem and an effective treatment plan to fix the problem. My obligation to the court is to ensure that the child receives an accurate diagnosis of the problem and that the court can rely on for its decision making surrounding the child. So that's my role as a second opinion consultant in these matters because of my specialized expertise. Look at me, old guy. I've worked a lot of pathologies. I've worked a lot of clinical psychology. And 15 years in the family courts. So when I'm brought in by an attorney or parent as a second opinion, my role is to ensure an accurate diagnosis for the treatment plan and an accurate diagnosis for the court's decision making. Because if we get an accurate diagnosis and fix the problem in the child and family, that satisfies the parent client who brought me in and their attorney who brought me in this situation. And if I can get that an accurate diagnosis to the court for its decision making, that satisfies the attorney client and parent client. That's why they're bringing me in, is to ensure an accurate diagnosis. I'm not an advocate on either side. The legal system has advocates. They're called attorneys. I'm evidence. I'm a doctor. And I do one thing. I diagnose and treat pathology. So you send a matter out to me, some pathology out to me. I'm going to look at the symptom features. I'm going to do a pattern match to diagnostic criteria, just like a judge would pattern match the evidence to the legal statutes. I pattern match the symptoms to the diagnostic criteria and render a diagnosis that then leads into the treatment plan. I do that. and then everybody else can do what they do surrounding the problem, and we can fix the problem for the children. With all due respect, the legal system lands on the wrong end point for this. It lands on the custody decision of the court. That's not where we should be landing. Treatment, healthcare lands on treatment. Okay, we need to fix the problem. Fix the problem with the child's attachment bond, fix the family conflict, fix the problem. That's a treatment plan. And I need a diagnosis for a treatment plan. The treatment for cancer is different than the treatment for diabetes. Are we treating cancer or diabetes? Are we treating child abuse by the targeted parent or child abuse by the allied parent? We need an accurate diagnosis for that, for the court's decision making, and for treatment going forward. So with that, that's my direct discussion with the court. I would recommend that the moment the court receives one of these complicated cases, it's coming back and it's about custody, immediately send it out to the healthcare system for a diagnostic assessment. Now, from the diagnostic assessment, telehealth second opinion, I would anticipate that the healthcare system could return a diagnosis within 6 to 8 weeks for around $5,000 probably. And then you had second opinions relative to each one of those parents bringing those on. But $5,000 for that primary assessment in 6 to 8 weeks we should be able to render a diagnosis on the problem. If you decide you need assistance with your custody decision making and you want to get a forensic custody evaluation, do so after you get the diagnostic assessment. But I think if you get a diagnostic assessment out of the mental health people, you're going to have enough information for your decision making. Plus, we always have something called response to intervention. We can send it into treatment. Now, given your current situation where the mental health system is failing you and not returning a diagnosis to you, sometimes you can look, if you're familiar with the diagnostic criteria, and you can look at the symptom evidence and you can make that connection. You apply the diagnostic criteria to the symptom evidence and you go, yeah, that's a delusional thought disorder. That's a false attachment pathology. And that would be child psychological abuse. Now, if you do that, and you look at the evidence before you, you look at the diagnostic criteria, and you decide there is a child protection response warranted in this situation, I would recommend you take that child protection step. On your authority as a court, there's child protection issues involved. Protect the child from the abusive parent, psychologically abusive parent, physically, sexually, whatever the abuse is, but you protect the child from that parent. And then the first thing to do is to get that child into treatment. And the first thing of all treatment is diagnosis. Are we treating cancer or diabetes? So it would be the responsibility of that treatment provider to then render the diagnosis that will either confirm the court's concerns or modify the court's concerns. We always want the diagnosis. There's no reason to separate a child from a parent if there's no child abuse. So and then we need the diagnosis to guide the treatment of delusional thought disorder or is there real abuse. So we need to settle on that from our healthcare perspective. However, until we get the court's good information that they can rely on, if you need to take a child protective action, take it, and then let's get the diagnosis as the first thing we do in the treatment phase. That would be also applicable if you've had 2-3 years of custody conflict and things going on, and 2 forensic custody evaluations and failed reunification therapy and things. We don't need another assessment at this point. We need to get this into treatment and fix it. We've wasted enough time on child abuse and unresolved child abuse. So make your decisions about what needs to move forward. And the first step that we would want to do is get that return diagnosis. And I would recommend that the legal system, the judges in your various committees and commissions and various locations, organizations, and groups begin to advocate with the mental health sector, with the American Psychological Association, AFCC, about why aren't you getting us diagnoses we can rely on here? It's up to the mental health professionals, particularly the forensic psychologists who work in the family courts, to meet the needs of the court and to meet the needs of the litigant parents. And they're not doing that. They're providing very low level, inadequate, malpractice level professional services. And we need to substantially increase the quality of the mental health services in the family courts, and that the information that's being provided to the courts for their decision making. So with that, I'm going to wrap up this Sunday's coffee talk directly to the court. Thank you for taking the time to listen to the issues as I present them. So with that, I'm going to head off to my Sunday here.